Yes, the session is now live. Kindly start.
Good evening, everyone. Thank you for joining this NatHealth expert session on a very important topic. My name is Siddhartha Bhattacharya. I'm the Secretary General of NatHealth. Today, in the NatHealth expert series, we're going to deep dive into an area that has a lot of implications for healthcare. It is the Data Protection Act of 2023. And that is very important. It is meant to provide guidelines for consumer privacy and the way the data is secured. And as we all know, healthcare is both a user as well as a producer of a lot of the data. And the guidelines in the Data Protection Act will have large implications for healthcare. NatHealth, being an industry body that has the broad ecosystem of private sector of healthcare around it, has a lot of interest in this subject. So we have convened this expert series today, first of all, to gain a perspective into what are the key highlights of the draft guidelines and what implication it may have for healthcare. Thereafter, what I would do is, we're going to drill a little bit deeper into some of these areas, and hopefully, towards the end, we can discuss in terms of the next steps. I'm very pleased today to welcome two leading experts in this field from Khaitan and Company. First, Mr. Supratim Chakrabarti is a partner in the corporate and commercial practice group of Khaitan and Co. Supratim has advised eminent clients in relation to information technology laws in India, includes data privacy and cybersecurity related issues. As one of the India's leading data privacy lawyers, is ranked as a leading individual for 3 consecutive years for data protection by the Legal 500 Asia Pacific 2021, 2022, and 2023. And under his leadership, Khaitan & Co. also has been awarded as the Data Protection Law Firm of the Year. So we're very pleased to have him to be joining us today. He's joined with his colleague, Mr. Sumantra Bose, who is a counsel in the corporate privacy and data protection practice and TMT practice of Khaitan & Co. Sumantra has extensive experience in advising on privacy implications of new age technologies involving artificial intelligence and blockchain, as well as drafting of technology contracts such as SaaS agreements. He's also an expert on data structuring for large conglomerates and as part of corporate transactions. So we are very pleased to welcome both of you, Supratim and Sumantra, into this expert series. First, I would request you to maybe give your presentation and overview of what this holds for healthcare, and then we're going to deep dive into some of the areas thereafter. Thank you again.
Thank you so much, Siddhartha. An absolute pleasure to be amongst all of you, ladies and gentlemen. We'll start the presentation, and of course, we will have deliberations towards the end. Shmantra, if you can just make this full screen. Perfect. Yeah, I think we can straight away get started. Right. So you can understand that we have a very important task to cover right now, because the kind of people who have joined this particular presentation, the spectrum is large. Okay, there could be people who would know everything, and there are people who are just. So we'll try to cover everything. We'll talk a little bit about the basics about the Digital Personal Data Protection Act. We will also go into the nuances of the draft rules that have come out, and also what we're hearing from the market. We have been fortunate to have attended a number of the consultation meets that have been organized by the ministry. So very happy to share whatever the learnings, what we hear. Thankfully, these inputs are not embargoed by the ministry, so long as we do not really impute it to any particular person or organization. So that's absolutely fine. That was mentioned in the consultation meets. So very happy to share those wherever we can. Okay. First things first, I think some of the definitions that are there in the Digital Personal Data Protection Act. The idea is not to throw a book at you. The idea is to set and explain that what are the primary pillars of this particular legislation. First thing is personal data. This particular law, and which is very critical for the industry that we are talking to here, Personal data is any data about an individual who's identifiable by or in relation to such data. You could find yourself in multiple situations where inferences are drawn, from certain individuals, etc. Remember that if you are able to correlate any data to a natural person, it would fall within the domain of personal data. And therefore, be a little conservative and try to see that, you're compliant. The penalties are quite high, 250 crore rupees or more. It's quite significant amount. Therefore, it will be advisable that you firstly see that are you dealing with personal data, because this law is all about personal data. It's not about non-personal data. Second important thing is what hat are you wearing? Are you a data fiduciary, or with internationally this is called data controller, or are you a data processor? Okay. Who's a data fiduciary? A data fiduciary is an entity which either alone or in conjunction determines the purpose and means as to what has to be done with the personal data. I can give you many examples, but maybe let's pick up simple examples. Okay. In your organization, you would have a payroll service provider to whom you give, say, a list of employees and the respective salaries, and say these 1,000 employees should be getting these salaries on the first of every month. Now, you as an organization, as an healthcare entity, you would be the data fiduciary here, which is clearly telling the purpose and means as to what is to be done with the data. That service provider, which is the payroll guy, they are simply following your diktat. So they are data processors. They have no liability or responsibility under this law. Therefore, it is important that contractually you bind these players very, very clearly. And contract, I don't think has been as critical as it was earlier as we see these new digital laws play out. Recently, there was a ransomware, there was a cyber incident which occurred in relation to a startup organization, and many large organizations were taking help of that particular service provider. The sector regulator has asked the following questions. Question number one, do you have a contract with this party? Question number two, does that contract have provisions in relation to data privacy and protection? If yes, please highlight and provide to us. Question number three, have you checked that this particular party is actually able to stand behind what has been written in this contract in relation to data privacy and protection? Question number four, did you ever tell this service provider to delete any personal data, which is part of data purging and data minimization concept? If yes, please provide evidence. So you can understand that how this is important in every parlance, and definitely in a data controller, data processor scenario. You could also find yourself in a very tricky situation where multiple things are happening. Okay, again, let me give you a simple example. When we are traveling, our personal data is taken by the travel agent and also the airline. Both of them determine different purpose and means as to what has to be done with the data. So they are joint data fiduciaries. You have to see that in which all scenarios you are joint data fiduciaries, and therefore you are, required to follow the requirement of law, who are the position that you are holding. Third point is data processor. Very simple. In my example, it is that payroll processor guy. Any person who processes personal data on behalf of data fiduciary. Fourth is data principal, which is the individual. The law is supposed to be for protecting the data principal. Okay, globally, data protection laws are for empowering the individual in relation to their personal data. So this data subject, as it is internationally called, is called data principal in our law. Why I'm emphasizing on these nomenclatures, sometimes you will get these foreign documents like GDPR related documents, etc., which will call them out differently. You should know what these entities or these players are. So data principal is actually data subject. You, me, your employee, your every patient, these are all individuals who are giving you data. They are data principals. Why do we use these nomenclatures differently as from international parlance? When we asked Justice Sri Krishna, he gave an answer like this. He said that Supratim, after the Britishers have gone, I would not like to call any of my fellow Indians as data subjects. So we'll call them data principals. The underlying intent is that he intended that there should be a relationship of trust between the giver of data and the receiver of data. Okay, so data principal and data fiduciary. Data processing, when you see the definition of processing, it's almost anything that you do with personal data. Okay, so anything that you do with digital personal data, it will be processing. We can move to the next one. So in the next slide, yeah, as you can see, we need to know the applicability. Is this law applicable to me? Many a times when we do sessions, it's like I'm a small player or I'm a mid-sized player, is this really applicable to me, etc. Yes, this is applicable to almost every kind of players, and thumb rules are fairly simple. If you are, if personal data is collected in non-digital form and it is digitized, or if you're processing digital personal data, then this law is applicable. So virtually anything that you're doing with digital personal data, this will be applicable. Also, it is applicable to foreign players if they are offering goods or services to people within India. There are certain exemptions and exclusions. We will talk about this, but the simple ones are if it is for your domestic purposes. For example, you create a list of friends who will come for your birthday party, that's exempted. Also, if there is some information which is made public either by yourself, you have blogged about yourself, or there is some authority which is required to put out some personal data out in the open, then that's outside the purview of the law. We can move to the next slide. Consent request. I think this aspect is tremendously important for your industry, considering that patient data and healthcare space as a space anyways have requirements pertaining to proper consent being taken. Now this becomes even more granular and rigorous probably. So what is talked about in the context of consent? Consent should be specific, informed, unconditional, unambiguous, with clear affirmative action. Means no pre-ticked boxes. Okay, no silence is consent. Those things will not work. There should be an option to withdraw consent, of course, subject to any applicable law pursuant to which you are required to keep certain information. Then there is option to access the consent request in English or any of the 8 scheduled language of the Constitution, which is 22 languages. This is a bit onerous, I would say, but this is there in the law. And thankfully, there are certain tech tools which are getting developed, which are able to now translate English document into the 22 language almost instantaneously. These are not right now absolutely perfect, but they are getting developed at a rapid pace. So I'm sure that this will kind of become effective by the time the law comes into play fully. And here, maybe it's important to mention that the rules have come out by up to 18th of February. It is out, it's open for consultation. Probably a little more time may be given. Do not rely too much on it. But after that, there is a possibility that things will be assimilated quickly, and then there will be the rules would be rolled out. And once that happens, what will happen first is that the data protection board related provision will come into effect, and it will get started. It'll kick off, and the process to formulate that board will start. Also, at the same time would be given to all industry players to ramp up and be compliant with this particular law. What we understand is probably somewhere in the range of 18, maximum 24 months could be given. But trust me, we have seen the GDPR journey. 24 months given to EU players were also not sufficient to ramp up for such a law. Therefore, a word of caution here, whatever timeline is provided, the ministry is constantly also telling you this, that start preparing from now. The act is already out there. The rules have also, the draft rules are out. There is a possibility that not much would change from here. So there is nothing that we should be waiting for and get started. How to do it, of course, you can have like a 3-pronged approach. One is the training, sensitization, and workshop for your people. Second phase would be doing the gap analysis as to where you are today and where you have to reach. And the third one would be to plug those gaps, right? The last point here is you have to provide contact details of a data protection officer for significant data fiduciaries, which are large players, even in the healthcare space. If you have large hospitals and healthcare institutions, definitely this could be a watch out area. Even if you are not so, if you're not a large player, any size of player will need to have a person who's performing the similar kind of duty, just like a data protection officer. Any authorized person for responding to communications from the data principal, which is the individual, for exercising their rights. And you can also be kind of called by the authorities to provide responses whenever required, right? So we can, I think a key implication for the industry could be that patients may have to be provided with separate consent form in both online and offline settings, whatever you are looking at, and consent request has to be much more granular as compared to what you see today. We can move on to the next slide. Privacy notices. Okay, so now there are two parts. One is the notice, one is the actual taking of consent. Notice is something which has to be either given before you take the consent or at the time. Normally, in a digital parlance, this will be part of the privacy policy. Okay, so the contents that have been talked about in the notice context have to be there. Now, when you look at the draft rules, there's one area which you have to be very careful about, and that's written in point number 3 here, which is itemized description of personal data sought to be processed. Number 2, specified purposes of processing personal data and itemized description of goods or services to be provided or uses to be enabled by such processing. So you can imagine the level of granularity that we are talking about, apart from other things, of course, which you have to provide. One of the key implications, healthcare providers, example, like hospitals, clinical establishments, to revisit their privacy notice, and also I would say the consent and the existing practices of obtaining, how you are obtaining, what is the evidence that you are keeping of this obtaining of consent, because in a bad day, you'll have to prove that notice was provided and consent was taken, and you have to establish that as when and where and how it was done, right? So if it's in a digital mode, then the digital footprint has to be established. Can you go to the next slide? This is an important one because apart consent is only one ground of processing. Okay. There are other grounds of processing also, which are there internationally in other laws, including for India now. In your context, what could be most critical is for responding to medical emergency, point number 3 that you see here, right? In such cases, you cannot expect that you will be taking the type of consent that you're talking about if you have to save lives. So therefore, this is very critical. But there are some others also which are equally relevant and important for you. For example, point number 2, for the purposes of employment or for safeguarding the employer from loss or liability, such as prevention of corporate espionage, maintenance of confidentiality, trade secret, etc. Let me give you a little backstory for this. When this was being thought of, Justice Sri Krishna committee consultations were happening. We put forth a request that when we do internal employee investigation today, very technically speaking, when you look at the Information Technology Act and the sensitive personal data rules, you will have to take the consent from the individual who would have saved certain sensitive personal data in the laptop on the system of the company, unless you have taken the consent beforehand. So in a bad day, you can be almost certain that that employee will not be giving you such a consent. So what should we do in such cases, right? In such cases, we needed another ground of processing, which is for purposes of employment. And that's what you see in front of you. In a nutshell, if it is an employer-employee relationship, then you need not take consent for everything. Okay. It's understood, it will be covered under this broader relationship, but be careful. There could be certain fringe cases which are outside the purview of employment, core employment. So be careful. For example, family day, where you tell the employees to get their kids and the family and their photograph, maybe the office portal then puts up their photograph on Facebook, etc. So just be a little careful to take proper consent there, right? Point number 1 is also equally important, and this is called for specified purpose. Now, this is very situational in nature, right? Suppose then when in your hospital or healthcare institution, there is an individual who has come and the person is told that, listen, you have to wait for a bit. Why don't you give your phone number? I'll call you. And then actually when the person is called thereafter and the person can then go in and go for the checkup or whatever. Now, this does not require you per se just to make that call to first show notice and then show consent, take consent and all of that. But that is for that specified purpose. Up to that, absolutely fine. That you give me the number to call you back when there is a place ready was for you and we call you, right? But beyond that, if you're trying to do anything, for example, you're trying to check that whether this person actually bought the medicines that was prescribed, etc., that will not be permitted. If you want to do that kind of a tracking, trailing, etc., you should be then taking specific consent, right? We can move to the next slide, and over to you, Shwantru, from I'll keep chiming in wherever required. Thank you.
Thank you, Subradip. So I'll just take on this part, the second segment of the session, and I'll be covering a few key obligations again, which will have some impact on members of the audience here. So obligations relating to children and persons with disabilities, the principal legislation already provided certain restrictions on processing of data of children. And one of the key precursor requirements of even being able to process personal data of children is to obtain verifiable consent from parents or lawful guardians, the latter also being in the case of persons with disability. And the draft rules have also come out with more details on this. So basically, that voluntary, that verifiable consent is of different methods, and what it has to prove is that the parent of the child is an identifiable adult through voluntarily provided details of identity and age or a virtual token. As I mentioned earlier, that of course there's this requirement just to collect and process, but processing of personal data of children is outright not permitted when it comes to behavioral monitoring, tracking, and targeted advertising. There is also a restriction against any processing which may have a detrimental impact on the child's well-being. That detrimental impact phase has not been defined in the legislation or on the draft rules. Also, with respect to persons with disabilities, there's some pretty detailed requirements on the data fiduciary having to verify the relationship between the legal guardian and the person with disability. There are certain approved documents which a data fiduciary would have to check. So that's also quite an onerous obligation that has come through. In terms of key obligations, of course, wherever there is any ancillary purpose for processing data of children, you will have to ensure that there is verifiable parental consent. Of course, I should mention that there is that point on using medical emergency as a ground, but that will be more from your core services standpoint. There may be a lot of studies, etc., that might, of course, in the healthcare sector, there are a lot of studies, etc., which are also done for the benefit of patients and healthcare providers. So, these are things that will also have to be looked into, and I'll also cover that as part of the exemptions. So, moving along, relevant exemptions that are there with respect to processing of children's data. And fortunately the industry has been given some leeway. So any data fiduciaries who are clinical establishments, mental health establishments, or healthcare professionals, then to the extent necessary for the protection of health and provision of health services, the personal data of the child can be processed. This is very analogous to what I was mentioning on that medical emergency bit. Further, data fiduciaries who are allied healthcare professionals, they can also process data of children for supporting implementation of any healthcare treatment and referral plan recommended by such professional. Also, for creches and daycare centers, tracking and behavioral monitoring is permitted for children where it is in the interest of safety of children interest in the care of such institution. This may or may not be entirely too sort of valid for your industry, but these are the sort of use cases where processing of personal data of children has been permitted. I think key implications that we identified there is, allied healthcare professional. Of course, there's a number of treatments, a number of types of treatments, some which are recognized, some which are not recognized. So it'll be interesting to see how that one also comes through. But I think the principal point that I was making remains that, of course, processing of data of children for core health services, etc., is pretty clear. But I think on a lot of other aspects, such as medical studies, etc., that's not so very clear at this point. So on consent manager, this is something that's going to be a little bit future looking, but these are basically entities who will have an interoperable platform for the benefit of data principle. So individuals can use the services of these consent managers to manage wherever they're giving consent or withdrawing, etc. However, a consent manager also has a lot of requirements in order to be able to register with the Data Protection Board of India. So shareholding details of more than 2%, etc., will have to be disclosed. So currently, we'll have to see going forward what kind of entities are able to take up this sort of business, because that ultimately their incentive has to come from the data principle. This is not for the benefit of the data fiduciaries. So I think again, if there are any entities who are interested in doing this business, that will have to be well thought out in order to sort of avoid any conflict of interest. Because as I mentioned again, that a consent manager has to provide service for the benefit of the individual and not for the data fiduciary. Reasonable security safeguards. I think this one is really sort of course, from a healthcare provider context, there may be a lot of security measures already, but the rough rules provide for a fairly granular requirement of taking reasonable security safeguards, even as a baseline standard. Interestingly, one of the definitions actually referred back to the Information Technology Act on computer resource. And so basically, one of the requirements is that access has to be controlled to a computer resource. Now, a computer resource on the IT Act has unfortunately been defined to mean data, network, as well as all your hardware, software, etc., everything. So that level of access control is, of course, very, very difficult and time-consuming and cost-intensive. And that's not the only one. Of course, masking personal data using virtual tokens, and of course, ensuring that your data processors are also following these obligations through contracts. These are going to take a fair bit of effort, even for your industry. Of course, again, having sort of very extensive contracts is one thing, but ensuring that your data processors, such as your cloud providers, etc., actually things which are being passed down through the contract are very important as well. Intimation of personal data breach. And so the Principal Act had already stated that all data breaches will have to be notified both to affected individuals and to the Data Protection Board of India. And the draft rules have now provided for timelines and the details with which the reporting has to be done. So for affected individuals, there has to be a reporting without undue delay in terms of the description, the consequence, and mitigation. Unfortunately, there is no risk-based threshold of reporting. So this will have to be carried out for all breaches. And also, one aspect to think about here also is that the existing requirements of reporting to bodies such as the Indian Computer Emergency Response Team will also have to be adhered to. So, we're potentially looking at a number of reportings to different regulators for perhaps the same incident. And where this law also goes beyond, of course, is reporting to affected individuals. Now, with respect to reporting to the Data Protection Board of India itself, the first instance of reporting will have to be done without any delay, and that will have to include details such as nature, extent, timing, and location of the breach. The follow-up reporting within 72 hours, and which can be potentially extended by the board. Then details such as updates on the breach description, facts about events and causes of breach, etc., will have to be notified. I think the the issue of here is, again, in terms of reporting, etc., is that your industry in particular is definitely dealing with very sensitive information. Health information is generally regarded worldwide as a topmost sensitive category of personal data. So it's very, very important to have sort of end-to-end control over whatever health data is being processed in not only in your ecosystem but also in the ecosystem of data processors. Otherwise, it'd be very, very difficult to manage reporting of data breaches to various regulators.
Yeah, so
Right. I
just
think,
one,
yeah.
so just I'll come in and mention one thing here, which is what we are increasingly observing is that regulators in relation to breach are becoming extremely aggressive. Okay. So one of the tip which we may sort of you may consider is to prepare a single source of truth when an incident occurs. Okay. Where you pen down minute by minute what has happened and out you kind of take a leap and respond and give inputs to the regulators such as say a certain or a data protection board and also to the sector regulator, etc. What we are trying to request the ministry at present is that firstly there should be a whole of government approach. Okay, in a bad day we should not be expected that we run behind three regulators and try to give inputs, etc. If we can have a single portal where we do the reporting, and some jurisdictions do have it, okay, at the back end the relevant regulators are informed. That way you have lesser things to do in a bad day, and also within 72 hours you would probably not know anything. Okay, if you go and give half baked information to all individuals, you could be in a mayhem. But of course, there should be a risk-based approach. There could be certain things which need to be really immediately told to all individuals. But there could be certain things where you can consider that first you should understand what has happened properly, have cogent answers, and then go to the individuals and reports. What has happened in one of the previous cases is, say, 5 lakh people were to be reported because the cert in has also been nudging to go to the individual and do the reporting. Say 1,000 people come back with follow-on questions. Now your entire machinery in the organization is now attending to those, responding to the questions as compared to trying to contain the breach, and see that things are quarantined, etc., all of those. So these are requests that we are making. Again, I'm sure that we'll keep talking about this, but Siddhartha has also been requesting along with the natal team that we should be putting our representations to our points like these. It will be only helpful for the entire ecosystem. Back to you, Shwatra.
Right. And so, just moving along, to the last segment of the session. And so these are in relation to rights of data principles. So the parent legislation had brought out certain rights for data principles. These include right to access information about personal data. So, data principals have the right to access a summary of whatever personal data is being processed, as well as all the other data fiduciaries and data processors that are processing that person's data. Also, the right of grievance redressal. So, data principals have the right to register a grievance with the data fiduciary, and only then can they also make an appeal to the Data Protection Board of India. I think important aspect here is considering that the data fiduciary is the first level of dispute resolution. It's very important to have a robust grievance redressal mechanism within the organization, and not just on paper, but also to ensure that people who will be handling these requests, have the necessary acumen or are necessarily trained to ensure that there is an orderly escalation of grievances within the organization. This is, of course, the law is being significantly enhanced in India, and therefore, once this comes into force, it's very, very important to put the front foot on at least redressing grievances of individuals, because in many, many cases, people may not be entirely sure of what is right and what is wrong with the data. So there will be a lot of queries as well. So it's important to collate, have handy the necessary information, and ensure that the maximum amount of attention that can be given to grievances is given. So the other two rights, so right to nominate any other individual in the event of death or incapacity, and the last right was on right to correction, completion, and erasure of personal data. One aspect is that in terms of right to erasure requests, of course, in the healthcare industry, medical records are an important record to be retained. Of course, patient history can go back multiple years, decades even, and may be relevant for a healthcare professional or a healthcare organization. Of course, the right to erasure is not absolute. It is subject to retention requirements under law. But it's important also, where, certain records may or may not be required to continuously have some sort of monitoring and oversight over what kind of records are being kept, how long they're intended to be kept. So again, internally also having an idea of data retention, having a data retention policy, particularly in this sector, is something that is very, very important, regardless of if somebody is exercising their rights or not, because there are obligations on data fiduciaries to delete data once the purpose is over. So just the part on data fiduciaries, and the Principal Act had called out that there would be certain data fiduciaries who may be categorized as significant data fiduciaries by the government of India. Of course, we're still waiting on notifications as to which class or which data fiduciaries will be SDFs. But the rules enunciate further requirements of what a data fiduciary who will be an SDF will have to do. Of course, the 1, 2, 3 that you see was there in the principal legislation, appointing a data protection officer based in India, appointing independent data auditor to evaluate compliance, as well as periodic audits and data protection impact assessments. What we now know from the draft rules is that those data protection impact assessments and audits will have to be carried out every 12 months. Also, key findings have to be reported to the Data Protection Board of India. So this is an important sort of requirement that is there. It's practically like an annual filing requirement, which has been brought forth under the rules. And one other important thing that has also been brought about is that additional due diligence will have to be carried out when using algorithmic software for any sort of processing of personal data. This is, of course, there's a lot of debate on use of AI in the healthcare sector. So this one does come as a little bit of a surprise, considering that there's no particular definition of what algorithmic software is meant to be. But this just adds another layer of complexity. Aside from that, however, there's a big chance that a lot of healthcare providers may be categorized, or even the class may be categorized as a significant data fiduciary, because, as I mentioned earlier, healthcare data globally is considered to be, if not the most top 3 most sensitive categories of personal data. And one of the factors that the government will consider when it comes to designating significant data fiduciaries is the volume and sensitivity of personal data. So that's there in the act already. So that's an important one to note for the audience here. And yes, so sort of mentally and organizationally preparing for what is to come. Who will be your DPO? What will they do? What kind of data auditor will you have? Because once the act is enforced, that clock starts ticking. On an annual basis, that has to be done. So these are things to sort of take into account and take note of.
Just one thing which I wanted to just flag out here as to what we are hearing from the market as far as feedback is concerned on the significant data fiduciary. And just if you can just go back to the previous slide, Mansoor, what we're hearing in relation to the feedback. One is that DPIA, data protection impact assessment for some high risk processes is welcome. Okay, that's fine. Our industry is okay with it per se, it seems. But what is a little confusing probably for them right now, given the way it is crafted, it appears like that the requirement is that of a annual data protection, a DPIA to be carried out for the entire organization. That's number one. The number two aspect which people want some clarity against is that, of course, this data protection board was always supposed to be an adjudicatory body. Now, suddenly, this new element that has been brought in, that the DPIA and the audit that you carry out, the excerpt, the relevant aspects from there to be filed with the data protection seems like something which was unusual, which was never thought of in the context of data protection board. And how will the data protection board handle such maybe humongous volumes of significant data fiduciary reporting? So this request is, I think, also being made to be, to reconsider this. Again, if you have any suggestions, thoughts, inputs on this, please do submit it either directly or through Nat Health, request, and the spreadsheet has already been shared. Over to you, Shumantha.
Yes, so on cross-border data transfer, again, we've had a bit of a sort of change from the legislation. And while the Principal Act had talked about that personal data can be transferred to territories outside India, except as barred by notification from the Government of India, there's been a couple of developments in the draft rules. And one of those is that the government may notify conditions for transfer of personal data outside India with foreign government or their agencies. Presently, that's not clear if these extend to regular filings or commercial related filings. That's something we'll have to wait for and see what conditions these could be. The other is that this is more clearer, is that in terms of significant data fiduciaries, if there is a recommendation of the committee constituted by a central government, then significant data fiduciaries may be required to restrict transfer of both personal data as well as traffic data pertaining to that data outside India, and may have to process it and store it in India in entirety. Considering that this requirement is on significant data fiduciaries, and we've been talking about how that could definitely come into play for your sector, it's important to sort of look at where and what various service providers, etc., are also storing health records. What kind of critical data do you have that you absolutely need? Tomorrow if there is certain restriction on data transfers outside India, or if there is a mirroring requirement of data in India, that could require a significant amount of cost and effort. And so this is definitely something to look out for, and especially in terms of submissions to consider if you're concerned about that, because this is a very different understanding from what was there in the principal legislation. Of course, the principal legislation did talk about the fact that if there were sectoral requirements which required data localization, those had to be followed. But here it seems that the rules also do provide for that gateway of enabling data mirroring or data localization as well. Right. I think we've been talking about this part on research, and that's very important for your sector, in terms of medical studies and for benefit of patients and society. What does the Act have for that, and what does the rules have for that? So there was a exemption from a number of obligations for research, archiving, or statistical purposes. insofar as that is not used to take a decision on any particular individual. So basically, the meaning is that any such purpose would have to be processing personal data without taking any decision specific to an individual. The draft rules have now come out with what kind of standards that have to be followed in order to get exemption from other obligations. However, these are also quite broad in terms of ensuring purpose-specific processing, security safeguards, accountability, as well as data minimization. So, it's not a exactly sort of freewheeling type of exemption. There are quite a few obligations to be met. So this will definitely impact research activities. And so therefore, how presently, what kind of research activities are done? Are they purely sort of on an aggregate basis, or are there specific use cases or commercial cases? These are something to look at because if they're not falling squarely under this exemption, then all obligations under the Act will have to be followed for any research activity. Right, with that, we've come to the end of the presentation.
Yeah, and this is the QR code for the paper that we had written right after the rules had come out. So in case you're interested, you can read up more about it. Of course, very happy to share things, over email also. And over to you, Siddhartha. I think we can unshare the screen and talk.
Sure. Sumanta, do you want to talk a little bit about this paper that was written, the context behind it, for those who are listening, they'll get a little bit more insight.
Yeah.
Sorry,
So maybe, yes, I'll get started. So basically, as you're aware that the draft DPDP rules have, just been rolled out. And this particular paper was an immediate take on the hits and misses, what is this all about? Also, we wrote a separate sort of paper in relation to the impact that this will have on international businesses and few others. We can share all of those over email.
Sure.
Yeah.
Sure. Okay. No, I think this is very, very rich, and thank you for putting on a healthcare lens and adding the area specifically that may be of interest. I was kind of going through as this conversation was happening. There's a lot of questions in the sidebar. As an industry body, we have different facets that this particular act and the rules will touch. For example, hospitals, medical devices, diagnostics. And I was kind of going through all these questions that have come in with different lens. Broadly, I will classify them as into three buckets, right? One, and I think you've touched upon most of the broad categories. I'll just mention a couple of categories where they have talked about brand reminders, being able to, share data for promotions and medical educations, particularly with that in mind. So some of these are categories which probably also this act and the rules will touch. So they have kind of slightly expansion beyond, what is there. You covered 95%, more than 95% of what is covered. The second broad set of questions that are coming in is a lot of interest in clarifications and details. And some of these clarifications may or may not be there in the existing domain. A lot of it is probably ahead of us, but it's good that a lot of people have started thinking ahead how to implement and what to take from the respective organization's perspective. So we certainly, as a secretariat and NatHealth, will consolidate a lot of this, maybe reach out to you in some cases if those clarifications already exist, in which case we can say, these sections, this is already there. But in case it's not there, we can also document and keep it handy so that we can ask the relevant authorities. I guess the third, and that is where we really, really need everybody's input, is really what changes. What are the ones that are going to be the sticky points, and the ones where if existing recommendation is you got a different point of view on the existing recommendation. What are those? Is it an extension of timelines? Is it a certain difference in the way certain thing is written? Does it have certain unique aspects for healthcare? And this is particularly important not only in us sending it directly to MIT, which you can also do, but also the relevant ministries that NatHealth works with. I mean, they would be very interested to put on a healthcare lens. So please do write that, because we would be very interested in sharing our thoughts, not directly, not only with MIT, but also through the relevant ministries which touch upon and they create a position around these things. So I guess my broad question, I mean, third one being an appeal to everyone, and this deck really is going to be helpful, and our team is going to reach out to everyone with this recorded conversation. But in terms of the additional areas like brand, marketing, advertisement, brand recognition, are there any things that you would like to touch in those areas?
Right. Thank you, Siddharth. I think all three excellent points, and Sumantro, please feel free to chime in. So on the first one, brand reminders and marketing, of course, world over, when you look at regulations, marketing, etc., has been looked at with more closer scrutiny, I would say, has happened as compared to, any communication, which is for the purposes of the transaction per se, right? Though definitely you need a proper consent. And the platinum standard, of course, is that separate consent being taken through a different line item so that you're very clear. Some of the sector regulators are also nudging players to take clear consent in relation to marketing and brand reminders. Interestingly, Siddhartha, when we have been part and parcel of this journey from, again, like I told you, I've been doing this for 16 plus years. From July, August 2017, we have been following this making of the law. We traveled across the country with Justice Sri Krishna and, sort of took every note, every single word that is there. We know the history behind it, right? So one good thing about the government on this one is that they have been continuously emphasizing that, yes, it is very, very important to protect individuals' personal data, but it is also important to see that innovation, entrepreneurship, and ease of doing business does not suffer to the extent possible. India is at a very delicate stage as far as its economy is concerned, right? And we have learned some lessons from foreign jurisdictions who have maybe implemented very rigorous data protection law, and they've realized that there has been an impact on innovation and the economy has suffered, etc. So we don't want to go down that route. A suggestion to the ecosystem here is that we take practical sort of thought process. Of course, it's critical to protect individuals' data, and you'll have to, considering the space that you are in. But you have to also be thinking. I'll give you a simple example, Siddhartha. We're working on a telehealth application, right? Or a health app, and when you do teleconsultation, there are more granular consent which is required to be taken. Now, when the product team, all together, it became like the moment you try to get onto the app, there are tons of things to be signed off on when you try to get into the application for the first time. And of course, the tech team said huge drop-off rates would be there and there'd be friction generated, etc. So we sat down with them and discussed, and I asked one simple question. Everyone who's landing upon your app, does everyone go for a teleconsultation? The answer is no. Some of them could be going. So why don't we move that part of the consent to a point where someone is actually going for a consultation with a doctor, right? What happened is this was solved fairly easily then, and for the individual, look at it from their lens. It's more meaningful consent. It's like when you're going in the road, it says turn right, do not turn left. So you're asked that question at that relevant juncture, you're given more meaningful content. That's your first point. Second one is clarification and details. So I think please do not expect the moon is all that I would say. But if there are things which would really be hurting you, pinching you, do make a point more cogently there. And do not give prose and poetry around it. They're not going to read it. but be very specific as to what is it right now, what do you need it to be like changed to, and what is your rationale for that. Simple bullet points will also work if it's a very hard hitting point, right? I have given some examples, and this kind of ties in with your third question, what changes and sticky points and differing views. One thing which we have been doing this fairly frequently now is breach reporting. We clearly think that in a bad day, please do not put that business under further stress of running behind three regulators two times, and then also reporting it to individuals who will come back immediately, and then you take a risk-based approach there. That's a far better idea. And globally, that is true, right? If you look at some of the mature jurisdictions which have got laws, for many, many years now, we can take a cue from there, learn to take the good from the good and the good from the bad. So that's one thing which I definitely think we should talk about. Few others have spoken. I think the granularity of consent, for example, is good, but we need to be creative as to when we are drafting it. There was a gentleman seated next to me when when we were doing the initial consultations, and that person was from the telecom sector, and the person said that, listen, we are providing voice and we are providing data. Now, do you want me to split it up that this data for voice, this is for data? Maybe it is kind of one and the same. So the minister at that time had said that, listen, a prudent person would more or less understand that this is telecom service. For telecom service, you would need, and voice and data taken together, we would be required. So you can club that and draft it properly. Put yourself in the shoes of an individual who's trying to understand why my data is being taken, and just apply that yardstick, right? So I think, in a nutshell, that's what I wanted to convey.
Great. So we are almost on the dot of the hour. I would, of course, wrap this up with 2 or 3 simple requests. One, exactly in the format what Supratim just said and Sumantra echoed some time back. Please do let us know the very specific areas of suggestions, concerns, changes, particularly the clause number, the current as is, what you want it to be, and shortly, what is the rationale and the impact that this would have in case it's not changed, particularly from either your lens or from a consumer lens, which is very, very specific. The ones, where there's a lot of clarification and ask, I'm sure we'll document and we'll try to get this across to you at the soonest when it's available. We'll also share that these are important informations which are required to be shared, and where it is already available, hopefully we'll be able to point them to you. With Khaitan and Co, I first of all would like to thank them for documenting this, and I'm really hoping that they would continue to in some of these areas of clarifications we'll be able to reach out. We certainly will share this deck and this presentation and the recorded video today with our the entire ecosystem within NatHealth. But also, if you see certain broad themes which are kind of cross-cutting beyond healthcare, because NatHealth only looks at healthcare, and there are other sectors, on certain issues, we are probably better off not only talking about it ourselves, but along with others. That would be a great help in case we are able to rely upon you. But I think there is the time is short. On 20th of February or around there is the deadline for submission. And today we are at the end of January. So hopefully in the next 10 days or a couple of weeks, we can get everybody's thoughts incorporated. I would like to thank my colleagues, Vrinda, Anugraha, as well as Jayata, who have been instrumental in putting this show together, inviting everyone, handling the logistics around it. And my special thanks to Khaitan and Co. Supratim, Sumantra, thank you for being there and helping us through this.
Thank you so much, Siddhartha. It's absolute pleasure being here. And just one clarification, the date is 18th of February till now. So I think we should move quickly and get this collated. We should not rely on extensions and all of that, because let me give you some statistics. 6,000 submissions have already been made to the ministry, just so that you understand the gravity. Yeah.
Fantastic. So that shows the urgency, and let's make it in the next 10 days or so. Let's get moving. Thank you so much. Take care,
Thank you.
everyone. Bye-bye.
Thank you. Bye-bye.